controversy up in Polson about some of the kids who got in trouble with their T-shirts. The Whitefish, the lawsuit filed recently against the Daily Stormer's editor for the harassment of folks in Whitefish. The Washington football team's logo and its trademark status, which is offensive to many people. And even, I figured, it's kind of hard to see, but I have the Twitter account of the National Park Service, which is showing a bison. The day before it, should anyone remember that controversy, how the National Park Service Twitter account happened, around about November last year? They posted comparisons of the crowd sizes at the inauguration and then took them down. The Badlands and other national parks for a while also began to post other basically just scientific facts about climate change and some other things. But they eventually were told to stop too. And that's an example we'll talk about of government speech and what the limits are in terms of the government controlling its employees' speech. Actually not something that I know has been an issue just south of here with respect to the National Bison Range. Some of that as well. So there's pretty much something for everyone to disagree with here. And so we'll try to figure out whether we can reach some agreement on at least what the freedom of speech means and its importance for today. A few kind of questions, and this is kind of, it's not going to be that long, but I wanted to start by talking about why, some of the historical reasons why we have the freedom of speech, one of the reasons it's been defended, the principles underlying it, and then talk a little bit about some of the rules that we've seen at play, what is and isn't the freedom of speech. One of the themes is that word "the." It's not just any old freedom of speech. They're talking about something. It is a freedom. There are things that are within the freedom of speech and things that aren't within the freedom of speech, and that's often where the controversies arise along issues, and we can talk about these or other things too. Feel free to jump in and ask questions if you want. And some of the issues we're talking about is in terms of protests, regulating protests, questions about government speech, and I think most significantly in recent days in our communities here in Montana, questions of offensive speech or so-called hate speech. What the First Amendment has to say about these sorts of things. And questions and discussions at the end, but it's really, we're a small group, so feel free to jump in anytime. This is if you go way back, even before the Declaration of Independence, there's this fascinating letter. I always like to start with the history because it's a long time ago, but the people who wrote these had certain things in mind, and we want to understand what they were trying to do, what they were reacting to, what they believed. And so there's this interesting letter by the Continental Congress, the Congress that would eventually, a couple of years later, declare independence, where they're reaching out to Quebec, which at the time it had kind of gone back and forth between English and French control, but it was in English control, and they were trying to just let them know that their neighbors to the south were having some trouble with their shared king, and they just wanted to kind of clue them in on some stuff that might be happening in the next few years and why. This is before the Declaration of Independence, where they declared to the world why they wanted to declare independence. But they thought they were essentially they were explaining to their neighbors across the fence, saying, well, this is kind of what's going on, this is what we're thinking. But it gave them an opportunity to just begin to start thinking about what it might mean to have free speech in America. And what they tell the inhabitants of the province of Quebec. Here they're talking about the freedom of the press, and we can talk about the differences between the freedom of speech or freedom of the press. But they say it's important for the press because other than all the things we can learn in books, the idea is ready communication of thoughts between subjects, the fact that we can talk with each other about government and use those conversations and unite to shame or intimidate oppressive officers. It's the people's weapon, this press against the government, where they can shame or intimidate these oppressive officers and try to get them to be more honorable and just in conducting their affairs. And so there's a critical kind of core part, a very early insight about why, for example, unlike in England, where if the king was upset with you, you had to get a license to run a press, that you should have the freedom of the press. And in fact, in the early days, Benjamin Franklin was a big fan of this. When they talked about the free press, they literally meant the free press. Some states had in their constitutions that they would make presses free. You think about kind of free Wi-Fi or broadband access. This is the equivalent. We would make presses free so that anyone can come in and print their ideas and get them out to the community. Why? Because that was an important check on an oppressive government. When you get to the point where the people are ruling in a democracy, instead of, the tradition had been in Parliament, you could kind of say anything you wanted in Parliament. You couldn't be punished for what you said in Parliament because they were with the king, were the sovereign. They were the people who were governing, and they could talk about anything as they discussed it. But in the United States, when they gave that power to lead the people, suddenly we're all the Parliament. Parliament meaning from the French parle, to talk. We're all the Parliament. We all have freedom of speech to talk with each other in this way and try to control our government because we're the government. And just as they have freedom of speech only in Parliament in England, we now all have freedom of speech because we are the Parliament, the people in the United States. So that was the original theme. One of the very interesting things with the freedom of speech in the press that happened early on was just as soon as George Washington left office, the political parties arose, and John Adams, who was a great theorist and lawyer of the early United States, great contributor to our early legal system and constitutional values, but he didn't like what Jefferson and his political enemies were saying about him. So he passed a law, that the Sedition Acts, which made it illegal to criticize the government. It's quite interesting. It's a law that made it illegal to criticize the president or different members of the government, or I think some members of Congress and so on and so forth, but not the vice president. Who Adams' vice president was. This was before the 12th Amendment fixed this. Jefferson, his political enemy, was his vice president. So he said, passed a law that you can criticize him, but if you criticize me, I'll throw you in prison. And it sunset. It sunset as soon, the day he left office, the Sedition Act would expire. So a really vicious attack on his opponents, that they couldn't criticize him. But they could criticize. It wasn't, national security, we just can't talk about this stuff. You can criticize that guy all you want. And then when I'm out of here, you can criticize the government all you want. You just can't criticize me right now. And so Jefferson and Madison, working for the legislatures of Virginia and Kentucky, came up with these resolutions. And Madison, who was the author of much of the Constitution and the framer of the First Amendment, said, no, this is wrong. This was essentially a political campaign. The running against the government, Virginia and Kentucky, said, no, this is wrong. It violates our right of freely examining public characters and measures, free communication among the people. That's the only effectual guardian of every other right. If we're a democracy, we need to talk to each other about this. And so these early themes of the free speech really being about self-government. What we think is our First Amendment, and we'll often hear people go, well, it's our first freedom, it's obviously the most important. That's turns out to be incorrect. The Bill of Rights that was proposed by Madison, it's kind of hard to see here. This is the Bill of Rights. Note that Congress, remember, Congress is the one who wrote the Bill of Rights. They wrote all of our constitutional amendments. But the First Amendment was actually our Third Amendment. The first two, one dealt with the size of Congress. Another dealt with, it ended up becoming our 27th Amendment in 1982 that dealt with Congress's ability to raise its pay. Those were our first two. The First Amendment was actually the third. So it wasn't really special and got first. It was just, James Madison proposed a whole bunch of them. Congress ended up setting out, I think about 12 or so. And then the states ended up ratifying, starting with number 3, and that became our First Amendment. But it was never the First Amendment by design from the start. So after that, so what happened after the Sedition Act was that the courts upheld it. The courts sent people to prison. The courts were packed with people from Adams's party. Adams did a very good job of packing the courts there. So the courts weren't a very good protector of free speech at the time. Who was a good protector of free speech at the time? Well, the people who voted Thomas Jefferson into office so that you could pardon everyone. And he said that. He said, this is unconstitutional. I don't care what the courts say. I think it's unconstitutional. All of the people who violated the Sedition Act were saying mean things about my political opponent, our party. And we really don't have much First Amendment law going on in the courts until World War I. And that's where we begin to see an even broader view of the First Amendment. So this is Oliver Wendell Holmes talking about the idea of the marketplace of ideas. These were laws where, because of concern during and after World War I, people were opposing the draft. It tends to, a lot of First Amendment cases, not surprisingly, deal with draft resistors, because the draft is a pretty high-stakes invasion of personal liberty with national security on the other side, so it's a very high stakes on both sides. People get excited and protests are common. But people were being convicted under similar laws that said, well, you're interfering with the draft. For example, someone who was handing out a pamphlet that had the 13th Amendment, which bans slavery. So they were handing out a pamphlet that quoted the Constitution and being punished for it. They were talking about making broad discussions about how the war was being waged simply for capitalists, other sorts of ideological battles. And some people were actually saying, don't comply with the draft, don't do that. In all of these cases, the court again didn't come to the defense of the speakers, the protesters in this case. But we began to see some dissents from justices who said, now wait a second, if we really believe in freedom of speech, we have to allow some risky speech. And so Holmes says in this Abrams case, the majority of the court upholds the conviction, but he says, it's natural for us to want to persecute people who disagree with us. If you're in power, why wouldn't you do that? That's a great idea. That's a great way to hang on to power. Except that's not what our Constitution is about. Our Constitution really has to be about those original principles about being able to criticize people in power. So Holmes defends it on the basis of the marketplace of ideas. Brandeis was the other justice at this time who talked about not just the marketplace of ideas about the truth, but also this idea that we should be able to express ourselves to become better people, to develop our faculties. And then this ringing discussion of how it is hazardous to discourage thought, hope, and imagination, and then the consequences of if you keep dissent bottled up, what's going to happen. That's something I think that still rings true in some of the cases today. If you discourage people from thinking, hoping, imagining, fear breeds repression, repression breeds hate, hate menaces stable government. Better to allow the safe path is to allow people to express themselves and then talk back. That's the way that we should handle it.
It's interesting how that applies right now.
Yeah, I mean, so as we think about that question of hate speech, for example, how far does this principle go? Is that what else are you thinking of?
Just the well, the National Park Service not being able to post certain things, and the EPA not being able to post certain things. It's just to me, the Constitution is probably one of the most fascinating things, that a document that was written so long ago is still so applicable today.
No.
And to see something like that was written 90 years ago,
Right.
and we're seeing it all over again.
Yeah, so this is going to be one of the tricks as we as we start thinking about, okay, let's look at the words and what the First Amendment means. And we can talk about Supreme Court justices and all, but of course the Constitution, the thing that belongs to us are those words. Those are our words, and so focus on them. So here's kind of a brief summary of what's this about. Well, you can actually learn a lot by just reading the Constitution. You don't have to dig up all of these cases and try to sort it out. That first one, Congress, well, that ends up being a little tricky, because Congress, well, we have freedom of speech against our state governments. We should have freedom of, does that mean that the president can lock us up if we violate that? Does that mean that courts can violate the First Amendment by issuing orders for us not to speak? It turns out that the courts have read that broadly. When they talk about Congress shall make no law, what they're really talking about is just any law that might authorize anyone in the government to, either through the law that Congress passed or just through acting in the government, you can violate the freedom of speech. So we have the freedom of speech against any federal government official. And then after the Civil War and the 14th Amendment, the 14th Amendment is what we call incorporate the First Amendment against the state. So we also have First Amendment rights against state and local governments now, since the 14th Amendment. So that's the only real trick about it. But otherwise, then you have these questions as you look at shall make no law. No law? No law? So you can think about all sorts of laws that affect speech, that you can't say things. You can't say, generally, there are false advertising laws. There are, even without getting into the kind of the real controversial areas, you sign a contract. There's all sorts of regulations that say, like, if you buy a house and you sign a mortgage, and the things you can and can't say or must say. There's all sorts of interferences with speech there. And so what does it mean, no law? Or does it mean, does it mean some laws, or maybe if you make a law for a good enough reason? That's going to be a trick. What does it mean when it says no law? There's some justices, Justice Hugo Black used to say, he'd carry the Constitution around in his pocket, and he said, no law means no law. But then you look at his cases and you kind of say, well, that's not one of those laws I was talking about. I mean no law, but that's not what I meant. It's none of this law. And so, no law, what would that mean? The key, I think, word that limits this is that idea of abridging. So abridging, what's abridge mean? You have something that's abridged. Abridged dictionary or abridged. Shortened, yeah. That someone's edited it, someone's looked at it and taken some words out to make it easier for you to read, or easier for them to have you read so that you agree with them, right? So the abridging, that's the key. It's not, that word means that there's something called the freedom of speech, and that government can't shorten it, they can't start editing it, they can't pick out content. And that's the key rule for freedom of speech, what the freedom of speech is about. Government censoring things, censoring the content of things. There are all sorts of ways government might regulate what we call the time, place, and manner of things. That you couldn't have a huge billboard right at the top of the hill in a way that might interfere with traffic, even though, well, that's speech. Well, it's speech, but we're not abridging that speech. We're just telling you have to use a smaller billboard, or you have to put it in a different place. Or the old example would be sound trucks, political campaigns, and they used to have, before the Facebook, I guess, right? They have sound trucks going through. Okay, you can do that, but you have to do it. You can't do it when people are sleeping. Time, place, and manner requirements, or even protests. You couldn't, if there were a protest, right? If the coalition decided to protest something, the county could have a problem if you decided to take your protest right out on Highway 93 on some blind spot at the top of the hill. They're not saying that you can't say it. They're just saying, we don't care what you're saying, but how you say it, we just want to maintain safety. So that word of bridging ends up being a real key point.
What's the legal basis for removing a protester who holds up a sign at a political rally that is contrary to the opposition?
Well, so if they're going around picking and choosing people based on the content of their signs, that would be a violation of the First Amendment. But there are other concerns. For example, if all of the protesters are in a place where they can't be because they don't have a permit or something else, that's often the way that we see these protests regulated. Or if they're trespassing. But if you have a protest out on the National Mall, it would be a violation of the freedom of speech for them to come out and arrest you because of what your sign says.
I think a lot of what was being done was saying, well, it was a private event, so we can choose who to remove.
Yeah, so, say more about what are we thinking about the example? Or is the protester not part of the protest? Is that the problem?
No, a person, just to give an example, let's say that there's a political rally going on and somebody stands up in the back and holds up a sign that advocates the opposing party, and that person is removed.
Well, if it's in there's not just a what is the freedom of speech, but where is the freedom of speech. So it depends where it is. If it's what we consider a public forum, if it's in a park or a government property, if it's on the National Mall, that's one thing. Now, if it's for example, I went to out of curiosity, went to a presidential campaign rally this past year, and the guy sitting in front of me held up a Constitution and was thrown out of the rally. Right? So similar. That's not what we would consider a public forum, because that campaign bought that space, bought that theater where they're holding it. It would be the same as here. Right? The coalition, the churches agreed to allow this place for the coalition. So there's a geographic element, a location element to where the freedom of speech exists. And on private property, generally, remember, it's about Congress making no law. If the owner of a building, or the person who the owner of the building has given permission to use, decides to remove people, that's not a First Amendment problem. It might become a little bit more of a problem if they bring in the police and the police start selectively removing people. But if it's one citizen removing another citizen from their property, or not any person removing another person, that's not a First Amendment problem, because it applies only to Congress. And that suggests a really important limitation. Shopping malls. Should you be able to protest in shopping malls? Should you be able to gather signatures? I'm sure you've all tried to get out of the supermarket with a bundle of groceries and someone's sticking a petition in your face to try to sign. Well, that's not a concern of the First Amendment. The First Amendment is concerned about government silencing you, not us silencing each other, which can be a big problem because more and more of our discussion are happening online. It's not the government, right? Facebook feeds or other things. That's all happening among private people. It's not the government.
How did Joseph McCarthy pull it off?
Well, some hysteria. There are times, this is one of the things that you have to, the Supreme Court, which we talk about these cases where they're heroes and they're protecting freedom of speech, they're not actually have that great a record. They didn't help us with the Sedition Act. They didn't do, They didn't protect speech much during the First World War, and during the Cold War, they did a pretty lousy job. So in one case, and to say nothing about the Senate motivated by political reasons and McCarthyism, even the Supreme Court during that time, they upheld the conviction of someone who was running a, it's probably a little too flip to say it was a book club, but it was basically a communist reading group. That's dangerous. We're going to punish you for that. So not only did McCarthy get away with it for so long, the government has gotten away with it a lot because the court has a mixed record. So abridging is important. It has to be Congress or some other government that's doing it. That's who it protects us from. And it has to be abridging. It has to be regulating the content of something as opposed to just where or how you say it. The courts, generally when they're doing it right, the court's sophisticated about that. If you've decided to say, if they keep looking and people with one message are told, well, you have to do it, this always comes up around presidential campaigns, and it's not clear that they're getting it right, but around presidential campaigns, well, if you have that message, you have to be 1,000 yards away, but if you have this message, you can be about 200 feet away. That's probably a problem, but generally the court really defers to protecting the president. But generally, the government can't pick messages it likes and doesn't like. That's the whole point. The last of the freedom of speech or of the press, just when we're thinking about it, the freedom of speech, those are technologies, those aren't institutions. So the court has said that, although a lot of the famous cases have the New York Times or any old blogger gets the freedom of the press. They're technologies. The freedom of the press are generally broadcast or print, the printed word media. The internet is probably freedom of the press, and freedom of speech is conversation or discussion, whether on the radio or in person.
What about schools, colleges, universities, that sort of thing? I mean, I would presume since if it's government, if they're government funds, then they pretty much have to tolerate more free speech? Yes and no.
This is where it gets complicated. Generally with government funds, the rule is that he who pays the piper calls the tune. So there was a case involving funding for public health, for women's health, and a regulation said that if you're receiving this money, you can't counsel people towards, say, abortion. And the court upheld that because they said, well, you're actually acting as a government agent there. If you want to take the money, the government program allows you to do that. Similarly, the line gets a little fuzzy, but if the United States government is paying for AIDS prevention services in Africa, they can tie that money and tell those people, as long as you're spending our money, you can't counsel prostitutes, for example. So on a public university campus, for example, when I go into the classroom, I have to teach constitutional law or whatever I'm supposed to be teaching them. I don't have the freedom of speech to go in there, and I have some academic freedom to decide how I'm going to teach it, but I don't have the freedom of speech to go in when the taxpayers and the student are paying my salary, to go in and decide to just do something else, put on a musical or something. So that's one piece, is that when the government is speaking, the government gets to decide its message, and it follows the money. The other piece of it, though, is what about the students in the classroom? I am the government, as I keep reminding them. Can the students have freedom of speech in the classroom? Well, there it becomes a little more complicated too, because of course the reason they're there, it's not like we're on the National Mall. It's not like we're in a park or at a protest. We're in a classroom with a function, and that if we can talk about anything in that classroom, if I can't penalize them if they decide to talk about math instead of constitutional law in my classroom, or decide to talk about any sort of other thing, that would mean the government couldn't work, the university couldn't work. And so I actually, within the school, I can abridge. I have to be careful, I can't pick viewpoints on one side or the other, but I can say we're only going to talk about constitutional law. I may not be able to say, but I don't want to hear from any Democrats. I can't say that, but I can decide, well, we're only going to talk about constitutional law. So actually in the university camp, it's interesting, in order to have freedom of thought in the university, you have to, the government, the professors have to discipline, limit the freedom to talk about whatever, or else students no learning would get done. Outside of that, on the campus, these campus protests, something that those are happening quite a bit now. Generally, those campuses, although the campuses often argue they're not, there you're talking, well, that is a classic kind of public forum oftentimes. And there is an area where if you're going to open it up to, we'll say, if you're going to open up to Bernie Sanders, you should probably open it up to Ann Coulter, for example, to take the example of her. So once you're outside of the classroom and they're just serving as a public space, then the First Amendment kicks in much more strongly. And you can't usually pick and choose your speakers. Yeah.
And you were trying to hone in on what you were saying about students.
Yeah.
Like the students in your classroom says something that is, just, maybe like blatantly racist, attacking another student or a group of people in the classroom. Like in Montana State University Northern this week.
Okay.
A student was, this very thing happened, and he was dismissed from the university for a week. And I was reading the speech, and I'm going, wow, that's pretty liberal interpretation. I mean, they've thrown him out of classes for a year, but he gets to play football. And he can play football, but he can't do any classes. It was a bizarre thing. It was like, how did they, his what he said was odious, but I was like, finding myself taking his side against the university, thinking, that's what students are supposed to do, is try to figure the parameters of who they are and educate themselves. And yeah, it was a gap. I mean, it was a horrible thing to say. They gave him a quote, and I was like, what? Dismiss it after a year for that? Really?
Yeah, I mean I think that's the toughest question, whether it's a free speech question or just a general question of how to manage a classroom is.
Yeah.
You have students, I mean, you're often dealing with difficult subjects anyway. You often are dealing with racism directly. Professors need to be careful to, and there might be some issues where there really aren't, it's not very productive to say, well, we want to hear both sides. And so when you talk about slavery, we want to hear both sides. That's not going to be a very useful educational exercise, right? But at the same time, think about what Brandeis was saying, right? We don't want to repress dissent. If people really think that, now we might ask that they say it civilly, but we might hear that. And so there might be in an African American history class someone who expresses white supremacist thought. Professors really need to take care to make sure that it's not harming, or actually under an obligation under federal anti-discrimination law, that it's not creating a hostile environment for other students. But at the same time, we have to be careful to provide some way for these ideas to get out there and on the table so students can react to it. So that's what the First Amendment is about, is creating that exchange, even in the classroom. I think that's exactly right, that's such a tricky issue that it's happening everywhere. It becomes a First Amendment issue when it happens at a public university. But it's happening around dinner tables or on the street or at protests or coffee shops. Jobs, right, at employment. Cartoons posted in bad taste, political cartoons. So that becomes, that's tricky. And there's a area called hostile environment harassment, where the court is feeling its way through this and trying to sort that out. So at the University of Montana, concerns about hostile environment for women. What does that require, especially when it intersects with speech? Generally, it's going to require more than just an offhand comment. It's going to have to be what the courts have said. It has to be severe or pervasive. So it has to be a really, really awful racial epithet.
There were several
Right.
in this Montana State Northern. Several of the students complained that they no longer felt safe
Yeah.
in the classroom. It was an environment non-conducive for
Right.
learning. They felt for their own safety
Yeah.
being around the races. Native American history class.
Yeah.
And it was a racist.
Oh, I'll look into that more. But it's generally going to take a little bit more than just a one-off racist comment.
Yeah.
It has to be repeated. It has to be severe. It has to.
It seemed to me that they jumped the gun, the administration.
Yeah.
There's got to be more than one way of dealing with this.
Yeah.
It could be the way the media express it.
And it could have been the way it was a Facebook thing, could have been, somebody's slant on what happened.
Well, and that's the whole. Does the university have responsibility for its students' Facebook posts? Is a whole other issue. I mean, and you think about a university. Well, try junior high.
They do, actually,
Right.
even at the University of Montana. The sports people who signed the letter of intent are advised, to put hate speech on Facebook and you will be take it down. And they did. And some of them haven't. And they are no longer playing at the University of Montana.
No, these are really.
It seems to me there's a pretty big difference between hate speech and just putting forth the idea that maybe we should have a white homeland or something like that. You could make that case, but you can't make the case that a whole group of people is completely inferior. So I think the professor's job is to start that discussion.
Yeah.
Does that make sense?
I think that's right, and I'll say, just lost my remote control. So there isn't a hate speech exception to the First Amendment.
Yeah.
When they talk about the First Amendment protects even the speech that we hate. There we go. Because hate speech, right? That's a content. That's a message. It's a message we might not like, but that's a message that someone's trying to deliver. You're not trying to say, it's not neutral to say, well, we can talk about all these subjects, but we can't do it in a racist way, because racism is the message there. And the First Amendment generally protects that message from government censorship, as long as it doesn't essentially amount to direct harassment of severe harassment of someone. And then what the courts say is, well, that's conduct. If you have a college roommate who is every day making racist comments about you, right, or someone else, at some point that's not speech anymore. That's conduct. That's a pattern of conduct and behavior, or at least that's what the courts have said when they've said that you can punish some forms of racial or gender harassment.
What is speech?
What isn't? Speech is so the court views it is speech is flag burning. Speech is
what?
It can be flag burning. It can be anything that a person does that is intended to communicate an idea or a message, and is understood to communicate a message, is what they say.
Is that speech?
It could be, yeah. So I mean, the classic case that established this was it had words. So, but was someone who wore a T-shirt that said "fuck the draft."
Right.
If you had a middle finger there, it probably would be equivalent. It's symbolic, but if you intend to express something, it doesn't have to be words, the court has said. Pornography can be speech. Anything that is expressing a message, basically, the court has said is speech. So that's pretty big. So even arguably writing a check to a political campaign, that's where you get his money speech issue. But they've said there's something to that. The number of zeros you put on, if you put more zeros on to one candidate than to another, there's something you're trying to communicate there, your support. Now, they haven't protected that as much as wearing a button or a t-shirt that says, I support the candidate, but they have protected it somewhat. In fact, Montana's campaign contribution limits were struck down. It's a violation of free speech because the court viewed them as too low. That's up before the higher courts. Speaking of Montana, so Montana, I'll just briefly say that we do have constitutions. We're talking about the Montana's constitution. It's actually it's just a lot more fun because it's 1972, and our friends and neighbors, the C.B. McNeil who recently passed, Bob Campbell from Missoula, who just came into my classroom. It's a lot easier to get him in than James Madison in my other Commonwealth classroom, right? Maynard Ellingson. Many of you probably know people who were there for the drafting of the Constitution. It's broader in many ways in the Montana Constitution. It's broader protection. Speech, expression in press. And so this goes to this question, what is speech? Well, they said, we don't want them to be too stingy about what's speech or press. It doesn't have to be words. Bob Campbell has told people that one of the things they're worried about in 1972 is hair length. Maybe that's expression. Hem length. Who knows? But it's broader.
Holding hands.
Holding hands. Yeah. I think that's... and impairing. Now, I've had students wonder, well, is impairing a stricter standard or looser standard than abridging? I don't know, but they've chose a different word deliberately. And the second part is more old-fashioned. But expression they're talking about, it's even broader there. So we've already talked about this a little bit. So what isn't the freedom of speech? We've already said there's hate speech is speech because speech about hate is a message. That's a message that is protected. But the court has said over time it's kind of worked out what we kind of think of as rules of thumb that said, okay, that's not within the freedom of speech, really for historical reasons, but also for kind of trying the principle of the matter. And so they said there are a few historic and traditional categories long familiar to the bar. Hopefully they're more familiar to citizens too, since this is about citizens, not about lawyers. In so-called incitement, advocacy intended and likely to incite imminent lawless action, true threats, and fighting words. Fighting words is a very narrow category. The Montana Supreme Court, unfortunately, had for a couple of decades basically said if you swore at a police officer, those were fighting words, and they upheld all sorts of convictions for that. They've finally changed that now. It shouldn't be, right? They've actually, police officers should have thicker skin. They should be able to handle someone saying the F word to them. But for a while, they said, well, those are fighting words. Well, no, a police officer's not going to fight you if you swear at it, But so fighting words is a very narrow category. We'll talk more about incitement to lawless action or true threats, which is a big issue in the internet, and some of what we're seeing in Whitefish. Criminal conduct or fraud, right? So, can I buy that pound of illegal drugs from you? Is not protected speech if you're actually in a transaction there. One of the interesting things is what about, you're driving down 93 and there's you're coming through Arlee, for example, there's a speed trap there and you flash your brights to someone who's coming the other way. That's an interesting kind of question. Is that protected? Fraud, right? If I'm lying to you to take your money, that's not protected. Obscenity, defamation, child pornography. Obscenity and note it's child pornography, not pornography generally. It's a relatively narrow category. We don't see actually a lot of prosecution of sex-related speech anymore, except in the case of child pornography because of the clear harms. Defamation, false speech about people is not protected, although false speech about public officials or public figures is protected to some extent, because of course of course someone in power is going to say, well, what you said about me isn't true. I really am good for America. You were wrong. I'm going to sue you, because we don't want that. False speech about private citizens is not protected, but false speech about public citizens or public figures or public officials, unless it's intentionally false, or we call actual malice, unless you mean to or are reckless about the truth, it is protected. They don't want us to be worried when we're criticizing our government to have to do a deep fact check. Because sometimes, it's more important that we just want to say that we don't disagree with something. And then finally, there's this category of some grave and imminent threat the government has the power to prevent. Although that's very difficult to sustain. One example that isn't that is, for example, publishing the instructions to make an atomic bomb. There's a famous case out of Wisconsin who said, cat's out of the bag. No, you can't punish someone for explaining how to build an atomic bomb. Examples. So threats and lawless action. It ends up being a relatively narrow category. And this has come up in the Whitefish case. So if a website that espouses white supremacist ideas, this has also happened, the case that is probably closest to what's, some of you familiar with the Whitefish case and the Daily Stormer and some of those issues. Probably the closest case to this that's that we have in this region of the country is a case with an anti-abortion group, an extreme group that would post wanted posters of doctors who would perform abortions. And whenever one of the doctors, and several of the doctors were murdered,